Are you able to see my screen? I'm sharing my screen. Are you able to see my screen? All right. Let me start from the beginning. So I was saying, we are first of all going to look at a summary of all the topics that we're expected to cover in this course. So the first topic is the Zambian legal system. And I say that the Zambian legal system is the bulkiest topic. And in terms of examinations, it is the most examinable, simply because it consists of a number of components. When we talk about the Zambian legal system, we are talking about the entire arrangement of anything that is legal in Zambia. So when we say something is legal, it simply means it has a force of law. So beginning with the origin of legal principles, the institutions that are involved in administration, and quite a number of rules that are used in the legal system, right up to the enforcement of the law, is what constitutes legal system of a particular country. So there are quite a number of issues that are involved there. And of course, bearing in mind the fact that law does not exist in isolation, we will be making reference to other disciplines, maybe such as how does law relate to maybe economics? How does law relate to business? How does law maybe relate to politics and so on? So we are just trying to try and appreciate the relevance of law in society, at the same time as we are going to learn quite a number of things that are related to the law. So the very first topic that we'll look at is sources of law in Zambia. That's a very first topic that we look at. Of course, we have the introductory part where we look at the definition of law, functions of law. Those are just build-up topics which are so small, but the main topic that we'll start with, we look at the sources of law in Zambia. From there, we look at the court structure. We'll look at the court structure, and apart from the court structure, there are other subsidiary topics which you'll find, such as statutory interpretation, maybe differences between civil and criminal law. Those are subsidiary topics. They are not main topics. And we have maybe topics such as the legal profession. Still under the Zambian legal system, we'll branch off a bit to the characteristics of democracy. So let me just explain something here. Common law and politics consists of a number of branches of law. So we'll not only deal with one branch of law, but we'll deal with several branches of law. So the very first part that I've just talked about is known as legal process. It is a legal process under the generic bachelors of law. This other part, which consists of characteristics of democracy, where we talk about separation of powers, protection of human rights, and human rights itself as a topic. This one is another branch of law, which is known as constitutional law. At the same time, when you look at the issue of human rights, there's another branch of law known as human rights law itself. From there, we'll look at the law of contract, which is also an independent branch of law. I try as much as possible not to complicate it for you, because law of contract is a complicated branch of law. We'll also look at the law of tort. I think most of us are familiar with negligence. We use this word from time to time, and we are familiar with some actions in negligence that falls under law of tort. I think we're also familiar with the terms such as defamation, for example. We'll look at land law. I believe that we are all affected by issues of land allocation. We talk about customary land, We can talk about statutory land. We can talk about issues of renting houses, being a landlord, improving areas, and so on. That is what land law is all about. We have jurisprudence, which is basically the philosophy of the law. Jurisprudence helps us to appreciate maybe why we have law, and also to understand the origin of the law. Why is it that we have a court structure, for example? Why do we have judges in court? So jurisprudence tends to respond to, I would say, quite a number of questions that we may have pertaining to the minute details of law. So whatever is being done now actually has a philosophical foundation, and this philosophical foundation is found in jurisprudence. And then we have Zambia's political theory. It may not be all of you who did a course as it's Zambia's economic and political history, but I think a good number of you did that course. So this topic is somewhat a bit similar to what you did. It's just a very small component from what you did, and perhaps look at the relevance of law in our political arena. So these are the main topics that we find in common law and politics. Are there any questions before I begin to go into details as I'm projecting the module? Okay, so now we begin to look at the details of the course. First things first, we are supposed to appreciate what law is and also to understand why the law is important. So there are several definitions of law. But above all, what you need to remember is that when we're talking about definitions in law, there are certain key terms which you need to uphold. Each time you're trying to define something, make sure that you uphold the key terms that constitute the definition. Because once you go off key, it simply means that the entire definition becomes wrong. Therefore, law is a set of rules which regulate conduct. This is the simplest definition that I can give of law. Wherever you have an assemblage of rules, a collection of rules that are followed in a particular place, to try and bring some kind of sanity in the manner in which things are done, then those rules that are being referred to say you can do this at this particular time, but you can't do this, this is the mode of conduct that you must observe, and so on. Once we have such regulations, just know that collectively, those are referred to as the law. And when we talk about a rule is basically a value. It is a norm that is upheld by a group of people. It can be upheld by a community. It can be upheld by a nation. It's simply a value. So these values tend to regulate the manner in which we conduct certain things. As such, when we look at them collectively, they form the basis of the law. And law exists at different levels. Law can exist just amongst a small group of people. It can exist at community level. It can exist maybe within a district. It can exist within a town. It can exist within a province until it exists at national level. And then it begins to go beyond national level, at regional level. And then it will begin to spread even to the entire continent, goes even beyond the continent until it reaches the level of international law. So law is basically found at different levels. And the functions of law or the purpose of law cannot be underestimated. Without the law, we cannot have order. It regulates human conduct. Why does it regulate human conduct? It is because as human beings, we are too ambitious. We are too adventurous. If you gave me an opportunity right now to say, do whatever you feel like, then I can possibly do something that will even surprise you. If people, such as maybe police officers, are just given the opportunity to do what they feel like, we would have chaos because this one would want to mount a roadblock. This one would want to begin arresting people. But there's always an order in which things must be done. So there our conduct is being regulated. So there's promotion of regularity and certainty because we're able to know that I'm supposed to do this and I'm not supposed to do that. It is a mechanism of social control. As we interact with each other, the law will say do not harm the other person, do not kill the other person. So it is a mechanism of social control. So meaning it regulates our conduct. It brings about order. Law also is society's foremost source of authority. If I mounted a roadblock today, no one will listen to me. Why? Because I am not acting under authority. But legally speaking, a policeman has been given that authority to act as such. Therefore, we all obey policemen. These are just a few examples of the importance of law that I am giving you. And if at all such a question was to appear in your exams, I would expect you to briefly explain each function. Unless the question reads, list any function, then you can just say promotes order. But if it is not listing, maybe it says discuss, meaning you need to add a bit of some explanation and give examples where you feel that an example will substantiate your answer. So that is the definition of law and the functions of law in society. I want to move on to talk about the sources of law in Zambia. So you may go into the details, not detailed notes. For me, I think this is enough. I'll be able to explain each and every source of law, but for you might need to look at the module. So a source of law is simply an origin of the law. It is a source from which we can get legal principles. In law, we do not just talk, but when we talk, we're always required to back up our arguments with authorities. So that is how it is. I have noticed that there are still some other people in that group. I don't know if I should ask them to join this meeting. I think they're still waiting. Give me a minute. I ask them to join this meeting if they're not in this meeting. I've seen some people haven't logged out. Okay, so some of your colleagues will be joining because they are in the other meeting, the meeting which is on Planet. But unfortunately, like I said, with that link, I'll not be able to share the lecture with you. So let me continue. So we're talking about the sources of law. So I said in law, you do not just utter statements or give a particular position without supporting that position with some kind of authority. And this authority that we are talking about in law mainly will refer to, I don't know whose mic is on. Kindly mute your mic. Okay, I don't know if you know, is it Mukukanjovu? Kindly tell him to mute his mic. He's in the other meeting, but we're able to get, I think, feedback from his mic. Kunda Mukuka, sorry. Someone tell Kunda Mukuka to please mute her mic. I don't know whether it's a lady or gentleman. Anyway, I'm trying to remove this person from the meeting. I'm failing. Oops. Let me try to, there are still people in this meeting, about 11 of them. I don't know what is happening. Yes, he's not in this meeting, but he's in the other meeting where I'm trying to tell Kunda Mukuka, kindly mute your mic. Yes, there are still people stuck there, so I'm trying to tell them to join this meeting. Anyway, I hope they are all here. I'm hoping that they are all here, but I think there are some who are still there. So, talking about the source of law, the sources of law, we'll start with the Constitution. We'll start with the Constitution. The Constitution is simply a written document which is used to govern people in a given country. Why I am saying in a given country is because we are looking at the Constitution at the level of a nation, because there are companies which have constitutions. We have a lot of other institutions which can have constitutions. But since we're looking at it in terms of the sources of law in Zambia, I would define it according to the definition given to it, that the Constitution is a written document which is used to govern the people and by which the people have agreed to be governed. That is the definition of the Constitution. In our Constitution is the Constitution of Zambia, Act number 2 of 2016 as amended. Why do we refer to it like that? It is simply because before this Constitution, we were using the 1996 Constitution. So the 1996 Constitution was amended, and the amendment became effective in 2016. That must have been sometime in February. And the Constitution has quite a number of functions. It is a very important document. When you look at the current debates going on about the eligibility of President Lungu standing for this term, when you talk about a lot of other controversial issues, you find that we only get guidance from the Constitution. Why? Because it gives us for the general organization of the state. It establishes the government of the state. It divides amongst the different wings that government will have, their powers, their duties. It establishes a number of other constitutional offices, and it gives us a backbone of all laws in Zambia. For as long as these laws do not conflict with any of the provisions in the Constitution, then they'll be held to be valid. What I have explained has two very important concepts that you need to understand about the Constitution. The first thing is that it is the supreme law of the land. It is the mother of all laws in Zambia. It is the backbone of all laws in Zambia, meaning it is at the top or at the apex of the sources of law in Zambia. It is number one, and there's no law which can supersede the Constitution, no matter what, here in Zambia. So we refer to that characteristic of the Constitution as supremacy of the Zambian Constitution. So when you ask the question to say, what is the meaning of supremacy of the Zambian Constitution? The meaning is that the Constitution is the most important source of law in Zambia. Secondly, all other laws must be in line with the Constitution. Any law not in line with the Constitution is now and void. That is the meaning of constitutional supremacy. The Constitution is an act of Parliament, quite all right. But there's a big difference between the manner in which the Constitution is enacted as an act of Parliament and the manner in which other acts of Parliament are enacted. What do I mean? Some of you are actually even involved in these issues. At the time of making a constitution, you need to know that it is a consultative process that is normally undertaken. The parliamentarians on their own do not have the power to tamper with the Constitution. That you must know. By definition, I say that it is the document which is used to regulate or govern the people, and by which the people must agree to be governed. Now, when we say must agree to be governed, it means that our leaders must come back to us to find out from us to say, how would you like to be governed? Now, you might ask the question to say, how does this happen? So, of course, it is not possible that they can come to us and ask us to start drafting to say we want clause 1, because when a constitution is being proposed, it is known, of course, it will be a proposed constitution. It will be a bill, constitutional bill, and the provisions inside are known as clauses. It only begins to consist of articles after it has been passed into law. Then we begin to call those provisions articles, clause, and so on. But before it is duly adopted, we just refer to all the provisions as clauses. So it's not possible for them to start coming to us individually and begin to say, can you draft what you expect to see in the Constitution? Then we begin to draft. It does not operate like that. But what they'll do is they will give this mandate of drafting what they will actually give this mandate to let me just respond to Mike. He's asking about the link. Let me just respond to him. All right. So like I was saying, there is normally a body which will be selected to look into the issue of drafting a constitution. So what normally happens is that this is a body of people who are experienced in the area of constitutional law. I'll say these are people who are well vested with the knowledge. Then they do draft up something, and while they're being appointed, they are given terms of reference which clearly outline how they are going to proceed. So they will draft up a document which is now presented as a draft constitution. Now, when that draft constitution has actually been worked on, we have several modes through which a constitution can be adopted. Your notes have explained those modes in detail, and I think for those modes in your own time, please find time to go through those methods, such as the Constituent Assembly. We can have the Constitutional Conference. We can have a referendum. Most of us are very familiar with the referendum because in 2016, we had a referendum which unfortunately failed. So that is what happens during the constitution making process. And then what will happen is that at a certain point, of course, they do make available the provisions of this draft constitution. They do make available the provisions of this draft constitution. At which you will be expected to go submissions as a citizen, but you need to have the interest, because I saw last time that they were publishing these in a Daily Mail or Times. Would develop interest to really look at the contents of the proposed constitution. So the few that responded are the ones who contribute to the constitution making process. So after you go through the clauses and understand, then you find your way to the place where you begin to make submission. I think we had, is it Government Complex, Civic Center? I remember for a long time they kept asking for people to make their submissions. Once it passes that stage, what we need to know is that the only body which has a supreme law-making power is Parliament. It will go back to Parliament for final adoption of the clauses. So Parliament has the final say before it goes for presidential assent to become law. Therefore, it is important that as we are voting during elections, we choose people who we know that will represent us ably, because Parliament has a lot of work when it comes to passing important decisions, such as this one, where they participate in the final part of making the Constitution. So the Constitution, yes, please, is that the question? John Mutare. All right, we proceed. The Constitution cannot be amended without a similar process taking place. So that is the Constitution of Zambia. I said the Constitution is an act of Parliament, but it is different from other acts of Parliament. So when we look at the second source of law, we are talking about legislation. Legislation refers to a written law. The other name is Act of Parliament. The other name is statute. So wherever you see the word Act of Parliament, statute, legislation, so this type of legislation that I am talking about is known as primary legislation. Why? Because it is coming directly from Parliament. It is coming directly from Parliament. So, it means that it is the parliamentarians themselves who are involved in the law-making process. So it means that it is the parliamentarians themselves who are involved in the law-making process. And there are 5 stages of making a law, which you need to know. The first reading, where the proposed law is presented to Parliament. Then the second reading, where the person proposing the law explains it in details, and debates begin at that point. And then we have the committee stage. Committee stage, this is a breakaway group whereby committees will be constituted to panel beat the law. Of course, these are committees, it's a committee of experts who later on at the first stage is first reading, second reading, third stage is committee stage, the fourth stage is the report stage where the committee reports back to Parliament. And then once the bill goes through, once the bill goes through the report stage, finally what will happen is that it goes for the last stage, which is the third reading. There are no debates might take place, maybe just correction of a few grammatical errors. Then finally it goes for presidential assent. So first reading, second reading, committee stage, report stage, third reading, and it goes for presidential assent. Once it is signed, then it ceases to be a bill, but it becomes a law. Okay, so DL department has informed me that the link on Planet is now okay. So meaning in the next lesson, we'll use the link on Planet because there's now someone who automatically shares the recordings with everyone once it is done. So for today, this information was not communicated earlier because the other recordings were locked, so your colleagues were stuck. So going forward, we'll be using the one on Planet, meaning you all get the recording. That is legislation, and that is the process of legislation. The other thing is that legislation comes in form of a printed book. Legislation comes in form of a printed booklet. And this particular booklet will have a title. It will have a title, if it is a Health Act of this and that of this year, that is how Acts of Parliament appear. But we have situations whereby Parliament runs out of time to make laws, so it becomes necessary that it takes its lawmaking power and gives other bodies to make laws. Then we'll call that as subsidiary legislation or secondary legislation or delegated legislation. Primary legislation, secondary legislation, or delegated legislation. Why? Because Parliament has given its law-making power to another body. So that's what happens under delegated legislation. So, of course, I've mentioned that before a law becomes a law, it starts as a bill. And we may have types of bill, like you'll find in your note, a public bill, which basically deals with issues which, of course, are in public interest. And then we may also have a private bill, which probably may not be introduced by maybe a member of government, and so on. So there are types of bill. A financial bill deals with financial matters. So there are types of bills in Parliament. So it means that under delegated legislation, those bills will always be there as well because they're being proposed. But the only difference is that what will happen is that before anybody which is identified as being capable of making law under delegated legislation can do so, there's something that is supposed to be done. A parent act is supposed to be given. A parent act will be given to that body. Which bodies can make laws under delegated legislation? I'll be coming to statutory interpretation shortly. Which bodies can make laws under delegated legislation? They are here. Ministries, of course, ministers in charge of ministries can make laws under delegated legislation, and they'll be known as statutory instrument. Wherever you hear an SI, statutory instrument, just know that it is delegated legislation. When local authorities make bylaws, maybe pay your, what do we call them? Maybe certain, to get a license for a restaurant and so on. Those will always be documented by the local authorities in terms of laws. Those are bylaws. We also have public bodies which make laws in form of rules and regulations. Public bodies, we have ZAWA, they have Energy Regulation Board. The government departments also do form codes of practice, circulars, and guidance. You'll find that maybe the Secretary to the Cabinet wants to issue certain instructions to make reference to circulars and so on. The National Assembly also makes resolutions of the House. And the professional bodies, they can have Law Association of Zambia, Engineering Institute of Zambia, Bankers Institute of Zambia. All those make their own laws, which will be known as delegated legislation. So what will happen is that after they are presented with the Parent Act, that particular body will sit and carry out their deliberations, but whatever they conclude must be taken back to Parliament under what is known as parliamentary scrutiny. So there's no law in Zambia that can be made without Parliament having a hand in it. So once Parliament okays that law, then it becomes a law, but it will not be it is what will determine the name that we'll call that particular legislation. You should know that we have advantages and disadvantages. Have any questions, quickly ask. As such, president can control the legislation and the courts. So when with the courts, Those are the advantages and disadvantages of delegated legislation. Any Are there any questions?
Yes, madam, can I come in?
If there are no questions, I will proceed to talk about we
Okay, colleagues, just an update. She's coming. She's still trying to reconnect due to network.
Are you able to get me? Can you hear me?
Yes, madam, we can get you.
Yes, madam. Yes,
Yes.
we can, madam.
Oh, okay, now my screen is showing. So I quickly wanted to talk about not delegated legislation, statutory interpretation. I assume there are no questions because I want to move away from the issue of statutes. Statutory interpretation is talking about the law which is passed by parliament or any other body. How are we able to get the meanings of those words? Because from time to time, even just normal English vocabulary, you find that we might have different understandings of the same words. So when a law is passed, the makers of that law normally have an intention. So you find that we reach a point where this law is supposed to be interpreted, but none of the makers of the law is there. So there are guidelines which have been developed to try and help us bring out the meanings of the words used in statutes. And above it all, a statutory interpretation is there to help us understand the intention of a particular act. How are we to apply maybe certain principles in a given situation? So that part is known as statutory interpretation, and statutory interpretation is a reserve of the courts of law, because when you look at the three arms of government, the arm of government which has the primary responsibility to interpret laws is the judiciary. So we have judges who are widely involved in statutory interpretation, and as they are doing that, there are rules which they apply. So we'll start with the literal rule. The literal rule is the most basic rule, and the literal rule states that words must be interpreted according to their natural and grammatical meaning. Words must be interpreted according to their original meaning without adding or subtracting anything. And under the literal rule, we have the case of Whitley versus Chappell. After this lesson, kindly go through the notes because I'm covering quite a number of things. Kindly go through your notes. Don't wait for the next lecture, or else you'll start forgetting what I've talked about today. So in the case of Whitley versus Chappell, what happened is that there was an act which was passed, that is the Street Offences Act, which was passed to try and stop prostitution on public streets. So when these prostitutes were taken to court, their argument was that, literally speaking, the law bans prostitution on public streets. But since we are, that is a different case. I'm talking about Smith versus Hughes. Whitley versus Chappell talks about electoral malpractices. So here, the law stated that it shall be an offense to impersonate a voter. So what this person did is that they got a dead person's voter's card. And after casting the vote, in court, their defense was that, literally speaking, a dead person is not entitled to vote. And for sure, literally speaking, this person was innocent, and as a result, the person was acquitted. So the literal rule states that interpret words according to their natural and ordinary meaning, even if doing so is leading to an absurdity. Of course, we have seen that in this case, there was an absurdity, despite the law stating that it was an offense to impersonate a voter. But the challenge is that there's one ill which was left there. A person still committed a wrong by using a dead person's voter's card. But there's something which you need to understand about the law. Law is a technical subject. And I think in a number of circumstances, people do not understand the law. That's why sometimes you can call lawyers liars. That is not necessarily the point. You can find a criminal who killed someone winning a case on grounds of technicalities. And unfortunately, whether one is innocent, if they do not understand their law well, they will lose the case. So like in this case, it was a matter of semantics, just playing around with words. So for different types of businesses, people buy goods to sell, but a lawyer, it depends on how smart you are with your language. That's what makes you to be a good lawyer or not. So unfortunately, there was an absurdity and this person went scotch-free. So this is what normally happens when it comes to interpreting statutes. You apply the rule which you feel will be the most appropriate in the situation. We had a number of times the issue going to the Constitutional Court where they were talking about eligibility and so on. What were they doing? They were simply interpreting the law. So these are the rules which they used to interpret. When you hear that State Council, this and that has petitioned the Constitutional Court, these are the rules that they use. That is the literal rule. Now, one of the most important functions of law is to actually promote justice. Now the question is, what can be done in order to avoid some of these anomalies that we find in the law? So if the literal rule does not work like it did not work in the case of Whitley versus Chappell, you try and remove that absurdity, meaning you have applied the golden rule. And the golden rule states that it is the rule basically which removes the absurdity that the literal rule brings about. So we are moving stage by stage. So Rees-Sigsworth is a case we find under the golden rule, where a son who killed his mother was not allowed to inherit her estate. Simple. Literally speaking, he was entitled to inherit according to the Administration of Justice Act of 1925. But because he was a murderer, they applied the golden rule by removing that absurdity of allowing a murderer to benefit from his wrongful acts. Now the mischief rule, I think that's the case that I was trying to explain, Smith versus Hughes, where an act was passed which banned prostitution on public streets. So these prostitutes were actually in a balcony. So they contested to say, since the act says on public streets, we have not committed any offense. The court applied the mischief rule. The mischief rule tries to remove the wrong which the makers of the law try to avoid. So it will go back a bit to the historical making of a particular law. And once they do that, what will happen is that the intention of the legislators will be found, and a number of questions are asked. These are the questions which are asked under the mischief rule. What was the common law before the act? What was the mischief and defect which the common law did not provide? What was the remedy Parliament was trying to provide? So you can see that we're just trying to find out the intention of the legislature. Therefore, in this case, when the prostitutes said they did not commit an offense, they looked at the intention of the legislature in the Street Offences Act of 1958, and it was discovered that it is prostitution that this act was meant to ban. But unfortunately, I would say that the language did not come out clearly in the act. So I must say that it is common to find these anomalies in a number of acts. Why is it so? It's because even the legislators, even the judges, they are not exempt from making errors. So whatever, I think a number of things that human beings might come up with later on might be found with faults. For example, the word might not explain what the legislators meant. The word used may be too general, where it has 5 meanings. Sometimes they may not have envisaged to say a certain situation will arise, like when Mwanawasa died, our law was silent as to who would hold the office of president in the event that a sitting president dies. This is what prompted the issue of running mate to be brought on board. So the goodness with acts of parliament is that they are a current source of law because they respond to current needs in society. Other sources that we'll be talking about are quite historical. So those are some of the challenges that we have when laws are being made. Errors will be there. But however, it is hoped that a good legal system must have competent people who, when they make the law, must stand the test of time. So the issue of amending the Zambian constitution from time to time, Bill 10, Bill 15, Bill 17, whatever bills are there, is a sign of inconsistency in our lawmaking process. The Constitution of America was written, I think it's over 100 years ago, and it has very few amendments, very few amendments. But our Constitution, which is very young, which only comes from as far as it's 1960 something, has been amended time and again, 1972, 1991, 1996, 2016, up to now people are still fighting to amend the Constitution. That is not a good sign of a legal system, which means there is a bit of instability somewhere. So, therefore, having said that, that is how the mischief rule is applied. We look at the intention of the legislature. When we talk about the purposive approach, it is a mixture of the literal rule. It is a mixture of the literal rule and the mischief rule. So I know on top here, I deliberately left out these. I didn't want to explain these first. Rules of language also help us to interpret. They also help us to interpret the law. Let me just take a call for a minute. Okay, I'm about to wind up. Let me just finish the part for sources of law. Sorry, I've seen a message. Let me just read. Oh, you have another class. Yes, I'm about to wind up. I think we have 7 more minutes. In 7 minutes, I can explain 1 or 2 concepts. Okay, so I was talking about the rules of language. They also help us to interpret statutes such as a jus dem generis, where they say where we have a general word following specific words, they'll be taken to have the same meaning. For example, if you have Coca-Cola, Fanta, Sprite, and other drinks, then we'll say that probably the next drink should be a carbonated drink as well. So expressio unis est exclusion alterius rule is the opposite of a jus dem generis rule. A jus dem generis rule is saying general words which follow a specific word will be taken to have the same meaning. But expression unis est exclusion alterius rule is stating that express mention of one thing is exclusion of the other. So even if they say cat, dog, rabbit, maybe it's talking about domestic animals, you can't take it for granted that the next word is also a domestic animal because it has not been expressly mentioned. Nocita exorcis means that words get the meaning from the company they keep. Of course, these rules are quite straightforward, but try to go through them. If you have any questions, then you should be able to ask me in the next lecture. So the next class, I think, will be more settled and we'll start early. And take note that the link that we'll use for the next class is the link on Clanet, which is the link which I posted, but I should be able to post another announcement. Is it Wednesday when we're having the next class? So thank you so much. I'll see you next time. When the recording is ready, I'll be able to share it.
Thank you.
Thank you.
Thank you so much.